and welcome to Legally Speaking with me, Tarun Nangia. Well, FEMA has been in news recently, and we all know that a lot of enforcement directorate visits have happened to very well-known industrialists in the recent times because of FEMA violations. And that is why there is a lot of promoter interest into what this is, which is principally the Foreign Exchange Management Act. But can prosecutions be done under this act if the transactions are more than 7 years old? And there are many such questions that need to be, in a sense, talked about today. And I have a very eminent panel joining me for this on Legally Speaking with Tarun Nangia today evening. May I welcome you, Senior Advocate Aman Lekhi. Actually, Mr. Lekhi needs no introduction. But let me introduce, he is served as the Additional Solicitor General of India. And first time on Legally Speaking. Good to see you, Mr. Lekhi. And looking forward to some good interventions from you today evening. May I welcome Senior Advocate Vikram Chaudhary, who we all know is a well-known name as far as PMLA and ED cases are concerned. And it's a pleasure to see you, Mr. Chaudhary. And looking forward to some interesting inputs from you today. Advocate Abhimanyu Bhandari joins us today. He's an advocate at the High Court and Supreme Court of India. And does a lot of ED matters, money laundering cases, as also FEMA cases. Good to see you, Abhimanyu, and looking forward to some good inputs from you today. At the outset, may I request that in about the first 2 minutes, Mr. Bhandari, if you could lay the ground for today's discussion, the landscape, before I move on to Mr. Lekhi for his opening comments. So 2 minutes for you, Mr. Bhandari, and then we start.
Sure. Thanks, Tarun. I think, Tarun, FEMA is now is a lot in vogue now suddenly. In 2015, FEMA was brought in because we all suffered the rigorous draconian law called FERA, which was a draconian law which made dealing in foreign exchange a crime. And there were rigorous penalties, and there was also prosecution. When FEMA was brought in to temper the severity of FERA and to ensure that violations done by companies and by individuals can easily be compounded, penalties can be paid, and matter can go on. Because remember that a violation of FEMA may not be a siphoning off of money from the Indian exchequer. It's not a tax evasion. It's not a crime where you're taking away money which the government is entitled to. This is more of someone's money who is sending abroad or is getting foreign exchange from abroad, which he has entitlement to. It's just that our foreign exchange barriers may not permit that particular kind of transaction. So therefore, to do away, and as our country was liberalizing, one of the reasons FEMA was brought in is because people said enough is enough. FERA is counterproductive. It is not facilitating international trade. Do away with FERA and bring in FEMA. So when FEMA came out, it was a civil offense. A civil offense being you were subjected to penalties. The law was very relaxed. RBI gave a lot of powers to banks who are called authorized persons under the Act to allow foreign exchange transactions to happen. You don't have to go back to the central bank every time you want to make a foreign exchange transactions. Current account transactions were opened up. Capital account transactions, they are master circular, which says what can be done, what cannot be done. For many transactions, you don't need anyone's approval. You simply need to submit papers to an authorized dealer, and he facilitates that transaction. If there is an error, then there is a whole compounding mechanism under the Act and under the rules and regulations where you simply go and file an application before the RBI and RBI will compound it. But all this turned dramatically when in 2015, the legislature brought in an amendment and said, here you go, a FEMA violation may prescribe 5 years of imprisonment. And I think that is a real change in the outlook of the law. A law which was brought to decriminalize something suddenly had a punishment of 5 years in it. It became a crime. And now with this coming in, I think FEMA has again become a very big and a very hot topic. Also remember, in 2015, an amendment was made where severe attachment powers were given to the competent authority to attach assets if certain assets are found to have been sent abroad in contravention of the FEMA law. This was not there before in the manner that it is there today. So therefore, I think the layout of the discussion is that are we now in a situation where the act which was brought in actually to temper the severity of FERA is now again coming back in a new avatar and may tomorrow come across as a very draconian law, which will again impede businesses and will create chaos and will create, anxiety among businessmen. Because remember, we can't live in an isolated village. Every business house has foreign transactions. And when you have a large number of foreign transactions, if you start looking everything with a microscope, you'll find 10 reasons to say, oh, this is not in accordance with rule, that is not in accordance with rule.
That's a very fair point. That
huge issue.
When you're running a large company, there are hundreds of transactions, maybe thousands. And if you look under a microscope, then, but I'll go to senior advocate Aman Lekhi at this point. A lot of promoter interest after the recent raid. The raid term itself generates a lot of interest. And when you say a FEMA violation, normally knows as a civil wrong. But now, as Abhimanyu pointed out, attachment and imprisonment, I don't know if it extends to possession of assets. Whether it only stops at attachment. Your opening comment on why is such draconian measure necessary? Attachment, second 5 years imprisonment. And because you've seen so many of such cases, your view on this?
Well, I concur with Abhimanyu. Insofar as the framework of FEMA is concerned, there's a paradigm shift from FERA. And the intent quite obviously was in tune with the changes in the economy. As the long title of the Act itself says, to in some way facilitate external trade and promote orderly development of foreign exchange. In that end, the emphasis was not on punishment. The emphasis was essentially on regulation, facilitation, and towards that end, in the event of violation, penalty. The issue, however, which I want to flag here, apart from what Abhimanyu pointed out, and where Abhimanyu is concerned, where 37A is concerned, what the provision talks about imprisonment is concerned, I'll just nuance that submission a bit. The issue I want to flag here is, as the case with most laws in this country, it's not the terminology in which the law is actually worded, but the abuse of the law in violation of the objective behind it. And insofar as the application is concerned, the application should be consistent with the intent behind the enactment. Unfortunately, what happens is, in most cases, the law is used for collateral purposes having nothing to do with actually the purpose behind the enactment. And this abuse detracts from the worth of the Act. And as the worth of the Act is in proper application, the abuse, in fact, leads to degeneration of the legal process itself. So, insofar as the use is concerned, I think there has to be restraint, keeping in mind the objective behind the enactment, and unless there's cause, there should be no unnecessary prosecution, because the threat of prosecution itself will inhibit business. And if the intent is to attract investment, the easy prosecution of it will deter it. There was some kind of confabulation some point of time wherein there was a suggestion that there should be more criminal prosecution, which RBI objected, because if you know, RBI is the regulatory body over here, the ED is the enforcing authority. And because the RBI is the regulatory body, in fact, the buck should stop with the RBI, and ED should be a subordinate role to the RBI insofar as the enforcement is concerned, because that will keep the enactment and the purpose behind the enactment in place. However, insofar as the issue, and a very pertinent issue Abhimanyu has always raised, is the question of imprisonment. Here, subject to whatever Abhimanyu says, I feel, and it's more because we are apprehensive of the use and move away from the terminology. Insofar as the imprisonment is concerned, the amendment is relating to assets held outside. And as far as the prosecution is concerned, the prosecution is not immediate, because the prosecution is in the discretion where that is concerned. I feel, subject to it being properly used, because you cannot go to 37A as a default provision that yes, imprisonment is warranted, because the purpose of 37A is to deal with 4, that is not giving information to RBI. Now, if the information is concealed and property is held, in the case of last resort, imprisonment can be ordered, not as a first instance. Now, what happens is, and that's a constant problem with Indian penal law. Because there's a power of arrest is the default option. Okay. Not knowing that arrest is not to be resorted to except for cause. And the cause has, again, the condition by the objective behind it. And again, going back to what Abhimanyu very correctly said, yes, there's provision for compounding here for my friend Vikram to deal with this later. What I want to flag is another concern, because compounding is something which is misleading where FEMA is concerned, because I had occasion to look into the aspect of compounding. There are 2 or 3 aspects of compounding which makes compounding not any less compounding. And that is because one of the provisions of compounding is that there should be no other prosecution by CBI or other agency. But the way in which prosecutions are launched today is there multiple prosecution by various agencies.
Yes.
And because there are multiple prosecution by various agencies, they can never be compounding under FEMA. And if the compounding in FEMA cannot take place, the purpose of having FEMA and the distinction between FEMA and FERA will go down the drain, because they can never be compounding. And in any event, just so that I don't consume too much time, the other aspect, the compounding, on the terms, because they're very subjective. What is the loss suffered? What is the equivalent amount which is to be computed? This is completely subjective. And because it is subjective, in so far as the meaningfulness of the compounding is concerned, it will be affected. So the 3 things I'm saying is the application has to be consistent with the intent. Easy resort to coercive process should be avoided. And compounding where necessary has to be realistically applied if FEMA has to be useful.
Point well taken. Thank you for sharing all these points, Senior Advocate Aman Lekhi. I'll go to Senior Advocate Vikram Chaudhary at this point for his opening comment.
Yeah, I will absolutely endorse the very cogent and erudite views of my brother colleagues. They have set the pace as to what is the ambit, sweep, and scope with which the intent with which FEMA was enacted, and how the misapplication or I would say more enthusiastic way of putting it, I would say the investigating agency, which is for the purpose of PMLA, which is Enforcement Directorate. Actually, Enforcement Directorate is the creation of the statute, which is Foreign Exchange Management Act. Under Section 36, this was the body created. Under PMLA, it is one of the now notified agencies. So there is slight overstepping of the jurisdiction. After the advent of PMLA and the wide sweep of powers under PMLA, the distinction for purpose for which FEMA was enacted, replacing FERA, as rightly pointed out, the regulatory regime gave way to the regime of management. The regulatory regime gave way to facilitating the trade, etc. It is losing distinction. The existence of power is one thing. To keep it in a statute like FEMA, you have similar powers as in under the Income Tax Act that the officers may have, whether it is pertaining to the powers available under the Code of Civil Procedure, whether the power of search or etc. All these powers, existence of power is one thing, but exercise of that power is quite another. So we are now looking at a scenario where it is being made more sensational. There are press releases consistently by the Enforcement Directorate itself. Now, whether it wants a pat on its back or it wants to deter the individuals or to sully them or defame them or to put kind of a fear or a deterrent in their minds, that is what we have to look at from a larger objective. These sensational disclosures, even if there is material for search and it is justified, why can't we wait till we arrive at some conclusion? Because the message which goes to all and sundry is that once, as I remember the famous quote from Justice Krishna Iyer's time, that the moment a person is arrested, his reputation is sullied for all times to come. Similarly, a search carried out on a prestigious organization, even if you have material, now till you arrive at some conclusion, now under the FEMA regime, there is an adjudicatory process. Something is brought before the adjudicating authority. Something is being, substantively inquired and then material collected. All these disclosures, all these sensationalism must end. In that, if I look at in that direction, it appears that most of the actions, though may be justified at their inception, they become actuated with somewhere malice involved. Once it is, the agencies go overboard. I have seen those cases, Tarun, where FEMA inquiry starts. And while conducting that inquiry, the Enforcement Directorate itself writes a complaint to the police or the CBI. Then the police or the CBI registers a case based upon that complaint. And the moment that case is registered by the police under the various sections of IPC, etc., the PMLA case is registered by way of an ECIR. So ultimately, a FEMA inquiry, forget about prosecution under FEMA, it takes you to two other routes, which is prosecution under the ordinary law of the land as well as under the Money Laundering Act. So somewhere we have to as rightly pointed out by my brother, Mr. Lekhi, very, very aptly put, that the application of these provisions have to be done in a very cautious and circumspect manner, lest it becomes an instrument of oppression.
Thank you, Mr. Chaudhary, for your opinions. I'm going to Mr. Abhimanyu Bhandari. Abhimanyu, you spent time in London, and recently we had United Kingdom's Prime Minister Boris Johnson visit here. A lot of capital from UK is going to flow to India. But we see many times in European investors, there are concerns. And now this concern is around the attachment of assets. Compounding is one issue, but when you speak of attachment, there is a certain worry. If you can share with us in about 2-3 points that when foreign capital looks at India, what is the worry? Because it's not entirely non-news that a lot of foreign companies have come to this country and walked out. And that is why attachment becomes important as an issue. If you can throw light on this.
Tarun, you must remember that foreign investors, especially if you look for them from Europe or from North America, they find this whole law of foreign exchange regulation pretty foreign, because in their country, there is no foreign exchange regulation. No, you must remember that in Europe and US, sending money from one country to another country is like me sending money to you from Vasant Kunj branch of State Bank of India to Karol Bagh branch of State Bank of India. So remember, for them, they see it like a completely different regime because they are not subjected to foreign exchange regulation in their countries. Now, when a foreign investor is investing here, he wants to be sure that he can repatriate his amounts back when he makes his money, profit. Or when he wants to exit a business and he wants to take money back home, he should be able to do that without facing a huge amount of regulation or slow regulatory process and then being subjected to investigations and raids and seizures. So FEMA really has to facilitate trade. We need to bring back FEMA to what it was before. I'm telling you, Tarun, I've done a lot of these FEMA cases. Corporates do transactions every day. A big company, let's say a big manufacturing company, will send thousands of dollars abroad for consultants, for architects, for service providers. Will get thousands of dollars inflow also when it is exporting its goods. Now, if you're going to subject these companies to meticulous search and seizures and raids just because you get information from somewhere, and the act gives the authority the power to go into someone's office and take their phones and take their information, then it sets in a paranoia. A company will ask itself, why am I doing this honest business? Why am I paying these thousands of crores of taxes? If at the end of the day, for non-compliance of the FEMA Act, I'm being subjected to a raid, I'm being subjected to attachment of assets. And then you suddenly stop me from saying that, oh, now we're doing a FEMA inquiry. Do you know, Tarun, that under the master circular, you can always send money abroad to service your debts. You can pay contractors. But once a FEMA inquiry starts, a company cannot, under the automatic route, pay its contractors, send money abroad. That whole automatic route regime comes to a standstill, and then it has to go and seek specific approvals. And if that kind of a system comes in, then you can imagine how much chaos it can create for a company, because then it will become bad debt in the books of foreign suppliers. So no company which is either investing in India or any big company in India investing abroad. Now remember, we look at it only one way. We look at it that, oh, a big foreigner will come and invest in India. If for India and its growing foreign exchange reserves, today we have 600 billion, more than 600 billion US dollars of foreign exchange reserves. For us, it's not only receiving foreign exchange. For us, it is that every person and every corporate expands its footprint abroad. It's important. Why today there is so much of Chinese dominance all over the world? Do you know that most of the French vineyards are bought by Chinese? Do you know how much Chinese wealth has gone abroad and now is influencing policy decisions in various countries abroad? It is high time Indians also do that. Now, if Indian businessmen have to go abroad and do this, then you have to ensure that you give them that security, that regulatory regime, which is without raids and seizures. Now, yes, coming back to what Mr. Lekhi said, and he raised a very important point. He said that ED should be subordinate to the RBI. So this FEMA regulation should really be left to the RBI. A very interesting case happened, Tarun, recently, because people go file compounding applications, RBI compounds it. And on nominal penalties, not very drastic penalties. But suddenly a case came up in the Delhi High Court where the ED argued that, sorry, once I've started my investigation, the person can't go and file a compounding application with the RBI, and RBI has no authority to compound without taking my permission. And we have now got a system where RBI asks the ED whether I can go ahead and compound. And I think this is absolutely wrong. In such cases, as Mr. Lekhi rightly said, and if I'm quoting him correctly, RBI should be subordinate to the ED, and RBI should always have the power to compound these offences, regardless of what level any investigation is going on.
Point well taken, Advocate Abhimanyu Bhandari. I'll go to Senior Advocate Aman Lekhi. He had to come in. He was...
No, I was not coming. I'm in fact concurring on this, correcting that.
You're concurring with Abhimanyu Bhandari.
Yes,
Okay.
I was not.
Okay.
But what I was saying was that ED will be subordinate, not RBI will be subordinate. So
yes,
I think so. Okay. That's all.
Now taking this point to you, Mr. Lekhi, foreign capital coming to India and their worries, and then raids and seizures. Do you think that for them, this is an unknown landscape, and there is a certain worry? How would you put it in your language, in your words, and what are the worries? Because principally you in your life have dealt with so many of such cases, from the government side, on the private side. Could you share both angles with us? Because you have the unique vantage point of addressing it from the government end for all these years as the Additional Solicitor General of India, and now in private practice as Senior Advocate at the Supreme Court.
Well, to reiterate what I said at the outset, the question is we should desist from haste insofar as the prosecution aspect is concerned. That is absolutely fundamental. And what Abhimanyu correctly said was that we have to talk about the Indian footprint, and that goes again to the very objective behind facilitating external trade. Now, that is in fact the purpose of this particular enactment. And therefore, the movement is basically from conservation to utilization and facilitation. That is in fact the movement from FERA to FEMA. And if the movement is considering the economic security which we presently have, and the way in which the economy is actually growing, the confidence actually to let the trade actually prosper. That has to be the motivation behind it. Unless, of course, there's cause for intervention. And as I said at the outset itself, that it is merely because the power is there doesn't necessarily mean it has to be exercised. That said, Abhimanyu compared it with other countries. I will not go to that extent because, in fact, our situation may not be in any ways similar to what is there in the US, UK, and to some extent regulation is warranted and is necessary. But the point is that we can't make a virtue of this particular provision by misusing that particular provision to negate the objective behind this particular enactment. That is what we have to be actually concerned with. Now, you pointed out that as far as my experience is concerned, because I got both aspects of it, what is my perspective? My perspective is essentially, and this is what I actually flagged each point of time there has to be cause for a prosecution. And the cause for prosecution should be rooted in the statute. And the reason should not be anything but infringement of the statute, but infringement has to be a substantial infringement, what Abhimanyu correctly said. Nominal infringements, merely because there's an infraction, does not necessarily mean that there must necessarily be prosecution, because there has to be play in the joints and a bit of flexibility, because any rigidity in the system will lead to collapse. So what is absolutely necessary is considering the objective, ignoring the nominal violations while focusing on substantial for cause. Now, even if it's substantial, the entitlement to proceed would be there. But while proceeding, because then the discretion comes in so far as the punishment. Now, the punishment itself, it should not be disproportionate. That is a fundamental principle of insofar as reasonable punishment is concerned, proportion. Now, because you got the power to impose penalty up to a particular limit, because you got a power to confiscate up to a particular limit, you cannot ignore the principle of proportion. And for dealing with proportion, you have to keep the objective behind the statute in mind. And anything in excess would be unwarranted. So you resort to prosecution for cause where there is substantial contravention, and in dealing with it, remain within limits insofar as imposition of punishment is concerned. That would be a reasonable exercise of power. And reasonable exercise of power is fundamental to any particular statute. And the problem here, as I said in the beginning, is not the statute, but the use of it. And the use degenerates into abuse. And where the use degenerates into abuse, disregarding the proportion, in that event, the very objective behind the enactment is lost. And so the reason for this being brought in would actually be frustrated, because you're not going to be facilitating external trade, nor promoting, what is the word? Orderly development. Now, this is the key. Orderly development would mean sound and intelligent regulation. Now, you deter external trade and distort the orderly development by having the enactment. So these are things which have to be considered while dealing with FEMA.
Thank you. Thank you for these inputs. I'll go to Senior Advocate Vikram Chaudhary. Mr. Chaudhary, two things. A, prosecution in 7-year-old plus FEMA transactions. Do you see that often? Secondly, because there is no income loss to the government in FEMA cases, do you think raids and attachments, do you think we should engage in such things? If you juxtapose your experience with your recommendations both.
Let me just preface it again, Tarun. See, legislation may require some powers which may be drastic in nature also.
Okay.
I said, as I echoed the words of Mr. Lekhi earlier, that it is how these powers are exercised is the determinative of the nature of statute, but whether it requires further changes or adaptability or not. We started from FERA to FEMA. We all discussed that. But I think somewhere we did not accept it with the grace and aplomb, confidence with which we should have. There was an earlier legislation called COFEPOSA, Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, under which a preventive detention order can be passed if somebody indulges in any activity inter alia relating to augmentation or conservation of foreign exchange. Despite the advent of FEMA and replacement of FERA, the penal regime earlier, still COFEPOSA was not altered. It should have been only POSA maybe, that is Prevention of Smuggling Activities Act. But the COFE part was never repealed. And yes, it was tested before the Supreme Court also, this argument, it did not gel. That apart, what I'm saying is 2000 this act actually comes into play. 2002 we enact PMLA. 2005 onwards PMLA also kicks in. So the regime, instead of being management on one hand, the government, somewhere the decision making has been dichotomous. It is sending confused signals. So the authorities have been given power, but that power how to exercise. So prosecutions, as Mr. Lekhi rightly pointed out, the prosecution should be the last resort. It is not the contemplation of the act. Prosecution is something which is to be done in a rare case. You should have the necessary ingredients of criminal jurisprudence in mind, which is mens rea and knowledge. All these are kept at bay, and you only go on to the basic, what you have found or what you have discovered. So this regime, the FEMA regime, needs some kind of, I would say, a relook at the things. One essential feature was compounding of offenses. As Mr. Lekhi pointed out, I'll repeat, it has to be guilt-free. If compounding entails you to make first disclosure of your own guilt, or then there are other cumbersome features, I don't think that is a viable alternative. We have to look at it from a different angle and also make it more pragmatic. It has to be more reasonable in its approach. We have to, if we one authority, say for example, Enforcement Directorate, there is actually no ED versus RBI debate that I see. RBI always remains the regulatory body, the brain, and the executing authorities with the Enforcement Directorate. I don't see any challenge there, except that since one Enforcement Directorate is entrusted with, I would say, multiple responsibilities today. What are they doing? They are, of course, they are creatures of FEMA, so they are exercising powers under FEMA. They are exercising powers under Money Laundering Act. They are also exercising powers under the Fugitive Economic Offenders Act and So there's, because of the multiplicity of the various hats that the enforcement directorate officer is wearing today, he has to make that rational distinction that at this stage, he's not acting in this manner. This is a different statute, requires a different approach. Not everybody is to be, approach has to be adopted, which is more belligerent or which is more offensive in nature. There has to be a toned down, a rationality, a pragmatic approach. That is the, I think, essential need of the hour.
Okay, point well taken. I'll go to Mr. Bhandari. Abhimanyu, two things I want to ask you. A, when files can be summoned from anybody's office, it's a very natural practice to do. Is resorting to raids, it hurts the promoter much more than any other thing. That, when there is a raid, it goes. And in terms of today's global news, it's in New York before, it happens in 5 minutes, the whole globe knows it. There are concerns. Do you think it affects businesses much more than the actual prosecution itself?
Yes, absolutely, Tarun. It not only affects businesses, it affects the morale of numerous employees who work in key managerial positions in those businesses. No one wants his phone to be taken. No one wants his personal office to be searched. No one wants that there is an officer coming into his private area for what? For a transaction which may have happened many years back, for a non-compliance because let's say you sent out some money for which you've not done correct reporting. So I think, the need of the hour is to bring in some kind of a mechanism where, and compounding is extreme because there you have to actually admit that you've done something wrong. There may be cases where a person has actually feels when he was doing the transaction, he's done nothing wrong. Have you ever read these master circulars? Well, I read these master circulars all the time. And they are not very simple codes to kind of, to interpret. They can have various interpretations. So maybe someone took a bona fide interpretation that he could do something in a particular way or could do a structuring in a particular way of a transaction, which years later, someone may feel, oh no, but that is not what we meant when we made the master circular. And therefore his interpretation was wrong. So that person may have made a bona fide mistake or may have made may have taken a bona fide interpretation. So I think like we have this advanced tax ruling system in our country, we should have something under the FEMA where a person can go before he's doing a transaction and say, look, this is the transaction I'm doing. Please let me know whether you have any issues with it. And if he's getting a specific kind of a response, and it should be timed because you can't tell someone, oh, if you go and take a response to the RBI, of course, RBI is open to give you a response. But if it takes 1 year to get a response, no one's going to do that because business will suffer. Or after the transaction has been done, there should be a regulatory framework where one can easily go to RBI and say, look, this is what I've done because I felt at that time this was the right interpretation. Okay. And there was really nothing wrong in my interpreting it this way. And therefore, if you feel there's something wrong, give me time to either unwind the transaction or let me pay some kind of a penalty and get going with it. But do not subject someone to this thing. And as Mr. Chaudhary rightly said, that there is a whole adjudicatory process within the Act. So why do you have to kind of, jump the queue and become overexcited at the beginning with the whole investigation? Let the adjudicatory process go on. And then if you feel that there is some information not forthcoming, and that information is critical, then you can resort to some kind of a raid or a seizure. But so I think in perspective, we need to bring back the old FEMA, and we need to ensure that we bring in more regulatory checks so that it becomes a purely civil offense and not a criminal offense.
Point well taken. Two final comments now. One from Mr. Lekhi, one from Mr. Chaudhary. Mr. Lekhi, one thing. Should there be a certain direction to the enforcement directorate that if the offense is say more than 6-7 years, don't go into it? If you have not prosecuted for 7 years, then there's no case to go back to the books of accounts after so many years. Do you think that can be done? Is that possible?
No, I don't think that is necessarily required because the question is not following a provision. The question is following a principle. And as far as the principle is concerned, keeping the objective, and you can't possibly multiply laws. They already have a maze of them. So I do not think that is necessary. What I would say, just developing upon what Mr. Bhandari said, was that, in fact, I have a basic objection to 13 because the word used is penalty and confiscation. Now, what is missed is confiscation is different from penalty because penalty is part of a punishment and confiscation is not. Because as far as confiscation is, that is basically reallocation. That is, you take something out and then make it available for the people at large for public benefit. And that is outside and different from forfeiture, which is covered by 53 of our Indian Penal Code. The problem here is and. So penalty and confiscation, which makes this a patently arbitrary provision for disproportionateness because it removes the discretion insofar as punishment is concerned. There may be cases where penalty is adequate, but because of the mandate, the provision, in addition to penalty, there's confiscation. But confiscation in its nature is different from forfeiture and hence not akin to penalty. So by mechanically talking about penalty and forfeiture, we bring in an element which affects the proportion of the punishment and then makes this provision itself an abuse of law, because it becomes something which is outside the contemplation of the statute itself. So what I would suggest is that what we've discussed, that restraint in the exercise for compelling reasons, when there is substantial violation, to deal with it in a manner which is in proportion, so as to keep the intent behind the statute in mind, and that entails an intelligent application of the statute. A mechanical application of the statute, mainly because the power is there to enforce it, would lead to abuse, which is happening right now, and that has necessarily to be avoided if the purpose behind the enactment is to be satisfied.
Point well taken. Senior Advocate Vikram Chaudhary, your closing comment today.
Yes, I'll again echo the thoughts and the very erudite discourse of my learned brothers here. But I would add to what Mr. Lekhi has just said. The word proportion is very, very, I think, vital. And I actually endorse it fully. There have been several instances where disproportionate penalties have been imposed upon directors, individuals who are related to certain companies for mere technical or venial violations. There have been these cases of, I would say, excess, which results in a general demoralization. Second aspect is that there are lack of strict timelines under the FEMA for the disposal of the complaints by the adjudicating authority. And then, of course, the appeals before the appellate tribunal are time-consuming process, coupled with the fact that we are facing today the list before the Supreme Court, where most of the tribunals are vacant. You don't have anybody presiding over an appellate tribunal under the FEMA. And now please also look into the fact that the appellate tribunal under FEMA is actually not only dealing with FEMA, it is dealing with maybe PMLA, it is dealing with, I think, SAFEMA, it may be dealing with, I think, the Narcotics Act forfeiture also. So one tribunal, so it is kind of choking the system and not having maybe easy access to justice or speedy access to justice. It is, I think, a big dampener in the overall scenario, the purpose for which the word facilitate, the word management was introduced in FEMA 99.
Thank you so much for all these inputs. But one key thing that we must realize is, because as we are growing from, say, a $2.7, $2.8 trillion economy to maybe $4.5, $5 trillion in the coming 4-5 years, a lot of foreign investment, which means a lot of royalties and a lot of other money which will be sent out to various countries, transactions will increase exponentially. And in the face of these increasing transactions, if there is such minute scrutiny, and then in the form of rates, could it deter foreign investors, which India actually requires at this moment? A lot of foreign capital to flow into India is what we need. That's it for today. I would like to thank Senior Advocate Aman Lekhi, Senior Advocate Vikram Chaudhary, Advocate Abhimanyu Bhandari for making time today, joining us at a short notice. This is not the end of it. We're going to do 2 more FEMA episodes in future, because given the kind of prosecutions that are happening, we will have to take up this issue up again. But that's it for now, folks. Thank you so very much.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.